Hi, I'm Patty Engel, and this is Renee Eldana. We're happy to be here again to give the legal update. What I found interesting, Renee, is we usually talk a few weeks in advance. We talk about, okay, what are trends you're seeing, what are issues we're having, and as I was looking at it last night, they really dovetail together nicely. There are some themes, and in fact, there are some topics that have already come up this morning, so it's actually a good segue. So that's interesting that seems like we're all seeing the same trends. So I'm going to start today, and as we've done it in the past, we enjoy an interactive exchange here. So ask questions as we go. We'll try to be efficient. We always have a hard time finishing it all. We have so much to say. So I'm going to get right to it. First item we're going to talk about today is the Andrew F. case. So this was a case that was argued in front of the Supreme Court on January 11th. I'm glad it was done before the new administration. I don't know what that would have done to the matter, but here we are. It's exciting for me because it takes on the big issue, FAPE. What is it? What does the district have to do to meet that responsibility of a free, appropriate public education? This is coming out of the 10th Circuit. So this was a student, a 5th grade student in Colorado, a student with significant autism. Parents, the child had been in the district for all his schooling years, and the parents were dismayed that the IEP seemed to be the same old, wasn't seeing progress, so they removed their child from the district. Drew went to a private school for students with autism, and lo and behold, the family felt he was making nice progress. So they filed a due process hearing request and were seeking the payment for the tuition for the private school. They went up the chain through the case went first to due process, and the administrative law judge ruled against them. Then they were in federal district court, and they did not prevail. And then they were in, for the 10th Circuit. And what is the seminal case is Rowley. It's like 35 years old. And it talks about there are two-prong approach to these FAPE cases. Is the district providing a free, appropriate public education? First is procedurally. Is the district doing what's required with following all the procedures of the law, holding an IEP, including the parents, having a written IEP document, procedural. The other issue, and that's really where the case, is all about, is that second prong. What does it mean to have, what's the expectation of this level of education? And Rowley says some educational benefit. That's how it's been interpreted. What does that mean, some educational benefit? That the IEP is calculated or designed to provide some educational benefit. And over time, it's concluded, or how we've been looking at this for all these decades, is more than de minimis. So a little more than a basic amount. And granted, it's always been looked at as this is not maximizing a district isn't required to maximize a student's potential. A district isn't required to provide you've heard the statement, not the Cadillac, the Chevy. However, over time and through amendments to the law, the argument by the family was, wait a minute, it's not just this floor, it's not just a little over de minimis just a basic, but rather meaningful educational benefit. The amendments to the law talk about progressing from year to year, making progress in the regular education environment. Well, how do you do that if all you're getting is this de minimis educational benefit? That there was a recognition here that these don't comport. So it was argued in front of before the Supreme Court on January 11th, and it appeared that the justices were amenable to this idea of just what I said. How do you progress year to year? How do you make progress in the regular education curriculum if all you're required to provide is a de minimis, barely above de minimis? So that is exciting for us to see. What I think we're likely to see some change in the language. What remains to be seen is how is that interpreted? What does that really mean for change? But I'm excited about it. And as I mentioned in my outline, the justices did have questions. So they were questioning the district's position of Rowley's been the standard. It's worked for 30 years. Why do we want to change a good thing now? So justices were questioning that. But on the other hand, they also questioned, geez, what Pandora box are we opening here? We don't want federal judges to have to get into the business of making determinations on what's an appropriate education for each of these kids, understanding that necessarily these are individualized programs. They need to be. So how do we come up with a standard given the variety of children, the variety of disabilities? So hopefully that'll be coming down the next few months, and stay tuned. Renee, any?
Yeah, just a couple of comments about that. I mean, our advice to school districts has forever been, regardless of the standard, you're never going to go into an IEP team meeting or a mediation or anywhere and say the words de minimis, ever, because it's bad for your relationship with this family. And our hope is that most school district clients that we work with didn't go into the business of education so that they could provide de minimis education to children. And most of them, their intent, hopefully, is to provide a really good education and to foster relationships with families so that they can be working together. I mean, that's the ideal. I think that, so for a lot of school districts, because of the culture that we have here in Wisconsin, that is, really, the mediation system is such a key part of it. People focus on relationships. They focus on doing better than de minimis. I don't know that I know of a lot of school districts that are going to say, oh, well, the case was decided, and so now we're going to do things differently. I think what it's going to do is it's going to help a lot of very well-intentioned special education administrators who are working with others, teachers who they're supervising, superintendents who they need to reach to say, hey, we need to do this or we need to do that. And they might be able to then draw on whatever the results of this case are, to be able to say, well, there's new law out there. Because sometimes when we need to push someone in a little bit of a direction, it's very helpful to be able to rely on something like that. So I think that's what we're thinking is going to happen. We're not thinking there's going to be like a huge change in how things are done, just an additional push for some people who need a little bit more authority behind them. Similar to what we're seeing we'll later talk about some of the Department of Education guidance on behavior, for example. It doesn't change the world, but gives some people a little bit more authority and push that I think could be really positive.
Is Judge Gorsuch involved with this decision?
Not that I'm aware of. I don't know if
my understanding is that he could be, and that he has in the past decided cases of this nature, so he has some familiarity with the background, which is spectacular because very few judges, much less justices, have any experience with special ed. So my understanding is that he could be, but that it's to date unclear as to whether he's going to participate.
No, I mean, 10th Circuit, was he involved?
Oh, in this particular
In
case.
this particular case, it comes from the 10th Circuit.
Right, and I don't recall if he was involved in this particular case. I know he's rendered some decisions regarding special ed issues in the past. Do you know if he was in this particular case?
No, and I haven't read anything. There's been no chatter, if you will, about, what will that mean? So-
Right.
So he's better versed than the Secretary of Education.
No comment.
Okay. We're all going to stay quiet.
From Minnesota.
Any other thoughts before we move on? Do you want to start with records, or do you want me to?
Oh, no, go
Okay.
ahead.
All right, so we're going to switch gears significantly to student records. And, a lot of times when families and districts come together in mediation, we tell them, you don't need to bring like the whole file. We're going to have a conversation. We're not going to go through, it's not a due process hearing. We're not going to go through all the history of the case. We're going to, sort of put that aside and chat. On the other hand, there are many times when families request records in advance of a mediation or in advance of a significant event, an IEP team meeting that you might be facilitating, for example, because there are things they just don't have in their files. They may be things that weren't provided in the past. We're only going to take a few minutes on records, but there's so much to say about that. We just want to give you a couple of basics so that everybody has a refresher as to the basics, and then talk about some of the issues that can come up behind the basics. So the first is right to records. And I think most of you are already aware that there is a state law and there's a federal law that talks about the fact that a parent has a right to receive their child's records. There are some exceptions to that, having to do with some psychological records. There are other types of things where if a parent has been denied periods of physical placement and they don't have custody and they're not allowed to see the kid, it's the question that we ask. If the parent's not allowed to see the kids, they're not allowed to see the records. And it's not just, I don't see my kids because I don't pick them up on the weekends. It's a court order saying mom cannot see the children. Under those circumstances, there would be no right to records. But otherwise, generally, parents have a right to records. Now, the issue that we get into is the second important legal piece, which is if you look at the law, it will say that parents have the right to records within 45 days. And Patty and I were chatting about this a little bit, and we were talking about the impact of a family coming to a district and saying, could I please have a copy of my child's behavioral records? For example, we've got this IEP team meeting coming up, or we have this mediation coming up, and the response being, yes, you can have that in 45 days. So if a school said to you, or to the family before the mediation, we have 45 days to provide the records, that would be accurate. And so once again, as we often do, we talk about what does the law say that we can do versus what should we do. And so there are a lot of conversations that I have with schools about, you do have those 45 days, that's okay, but maybe it's not okay. Why? Because you have a relationship and you need to work together. And if you really want to pin it on the law, there is, in the IDEA, a requirement for parent participation. And when Patty was talking about the two prongs of FAPE, the first one is procedural and the second one is substantive, and the one that really I think straddles both procedural and substantive is parents' right to participate. So because it is a procedure, it's a process, they have the right to be invited, to have notice, to participate, but they also then influence the program through their participation. So there's substance there too. So I think it hits on both of those prongs. So when we're in a situation when we're talking about law, and then we say, well, hold the phone, let's think about the relationship that you have with this family, if they're coming into an expulsion hearing, if they're coming into an IEP team meeting, if they're coming into a mediation, you want to make sure that that relationship is as strong as it can be under the circumstances. But then if we need to come back to the law again, then we're going to start talking about a parent's right to participate and how utilizing your full 45 days is going to affect that. There are times when we do utilize the full 45 days, and I'll explain one of those times. Custody problems, questions. We get a call from a parent we've never heard of before, and the parent says, I want all my child's records, I want that child's address, I want everything. And we've never heard of this person, we have no evidence that this person is a parent. We might say, hold on a second, and we call the custodial parent, and we say to the custodial parent, we've never heard from dad before, who is this person? And mom says, oh, bad news, please don't share any information. And we'll say, well, do you have an order that says dad's not allowed to see the child? And the mom says, well, no, but there's been significant abuse in the past, for example, and I don't have that order, but I wouldn't want for dad to know where the child is. And so then we will be in a situation where we might take our 45 days and say to mom, you can go get that order, here's resources for you. Like we're talking about before, you guys can't mention resources, but the district can, and then we'll try to take advantage of some of that time to be able to make sure that we're doing the right thing and keeping the child safe.
Absent that extraordinary circumstance, for me, it's a huge red flag. So this is very early in the process that I've submitted my request for letting them know I'm on the case, and now we're making what I consider a pretty basic and normal request for records. If the first thing they tell me is, yep, 45 days, I actually use the phrase, that's like the jerk factor, it's like, oh my gosh, here we go. I've never had it with Renee, but I have had it with other attorneys, and it's just like, this is going to be a difficult case. If you can't get me the records in a normal time, and I consider a normal like 7 to 10 days. If I'm not getting it, if I hear 45 days, okay, here we go.
Yeah. Any thoughts about that? Yeah.
Does that right to records, does that include protocols like from psychological testing or?
The test protocols that's shifted over time. So there was a time, and I think there's probably a lot of districts who are not up on this, because the test protocols used to be no test protocols, and then DPI said to us, well, actually, then you can't really see a kid's answer sheet and understand what that's about. Now, if it's psychological, somebody might say that that's one of the exceptions. They might say that that's psychological records, but if it's other test protocols, then the new guidance from DPI, as it's evolved over time, has been more like, well, you need to be able to sit down and go through with the family, here's the test form, and then here's your child's answers. Otherwise, the answer sheet would be meaningless.
Do the say for instance the report, individual report written, it's a piece of paper from the speech pathologist to the psychiatrist.
Yep.
All of those are
everything, emails, everything. So that's why, caution is important, because I think there's been times that we've seen where there's a records request and I tell the district, I need everything. If it has the child's name on it, unless you're emailing yourself and it's a personal note, if you're emailing someone else and it has the child's name on it, or the child is personally identifiable. Like there was this one district that kept trying to say the kindergartner with autism. Well, in that school, there's only one child in kindergarten who has autism, so we all know who you're talking about, so this isn't a secret. So I said, I think that counts because we can personally identify that child. Anyway, point is, it all comes together and then it goes, and then Patty and I sometimes have to work out, oh my goodness,
Right.
here's what's in these emails. This is relationship
Yeah.
destroying.
And I try to also, I am cognizant of the time factor or the labor intensity of going through like emails. So we might agree on level of importance and maybe stagger, like, okay, get me the special ed records, get me the behavior records, get me the CUME file in X number of days, and then if you could do the emails, over a longer period, because
Right,
I
yeah.
recognize that's big. And then sometimes, and what else I say is, I really don't care about the ones that just have his name in the whole class about the class trip. I'm really interested in the ones that are, designated, that are specific to this child. So that can help also.
Right, right. The other thing I wanted to mention about records from the other side, because as you all know, Patty and I switch hats a lot, because Patty used to be a special ed teacher and I'm a parent of a child with a disability, so it's like a 4 for 2 kind of thing here. And so I'm going to put my other hat on for just a second and mention that one thing that I have noticed recently that's really difficult is because I know what it means to a school district when you say, excuse me, I would like these records, or I would like those records. No matter how nicely you say it, everybody kind of goes, what, why? And it's sort of like everyone gets it. Maybe it's because it's me, I don't know, asking it, but however nicely you say it. So one thing that I have found has been really helpful as a parent is to try to have more open conversations about the types of records that I would like automatically. And one issue for me, because our youngest son has high-functioning autism and has significant self-regulation difficulties and is restrained. And the law says when it comes to restraint that they have to tell me he's been restrained, and then they have to put a report together. But they don't have to automatically send me the report. Well, it's not good news when someone calls and says, Renee, we're sorry, we need to let you know this. And if I respond with, can I have the report? That's going to seem aggressive, like, give me the report. And so we've talked about how can we handle that, so every time my response isn't send me the report, it's just a blanket request. It'd be great if just as a matter of course for my child, although I think it should happen for everybody, but as a matter of course so I don't have to keep asking. So those open conversations about what information would you like so that you don't have to keep asking for it, and then the district doesn't have to feel like, oh, what are you asking for, and you don't have to feel like you're being a pest or confrontational. I think working some of those things out as you're having your discussions can be really helpful. Right, what's next? Or does anybody have any other records thoughts?
I have a question. If someone does put in, a parent puts in a right to records, and maybe it's not the custodial parent, but they have some educational decision-making rights, does that include the mediation agreement if the child's name is on it?
Yes. So that we perceive that to be a record because it's got the child's name on it and because it's personally identifiable, and so it's in the child's file. Yeah, that is, and there's been a lot of concern. I know families moving from district to district even and saying, I don't want these things to go along, and there's a tension because the statute doesn't distinguish. It doesn't say these things but not these things, except as it relates to those very specific, like, the psychological records, but even those are sealed up and sent along with a note that says school psychologist. So
What if it was put in the mediation agreement that, could you argue to put it in there that this isn't part of this?
a record.
Probably not.
That would be tough. And I think it would be difficult because if there's information that's important to the next district or to know what these child's needs are and what was discussed so that they can pick up on that and do what they need to do. I've had a lot of people argue against, like, we don't want to send the disciplinary records to the next district, or can you not send my IEP? Well, no, Yeah. Sherwood.
Is there any difference between the state and federal law about timing? Or,
Not on the timing. There's no conflict there. There's some other sections of FERPA, which is the federal law, and the state law regarding pupil records that where there's some tension. But what we usually do, and the way that we guide school districts, and I don't know if you've ever referred families to this too, but DPI has a records and confidentiality publication online that sort of goes through everything that needs to happen in Wisconsin. So it's a great Wisconsin resource because it weeds through all of that and explains what DPI's position is on how to deal with those conflicts.
Next is the dogs.
Oh, dogs are up.
So
So I'm up
you're
again. All right. Oh, the dogs. Okay. Oh my goodness, like we were humming along with the dogs so well, weren't we, for a while? So you can ask 2 questions about dogs. And I think we might have talked about this before, but first we have to know whether there's a disability, and usually we already know that. We've already figured it out. We're a school, so hopefully we figured it out. And then the second question to determine whether a dog is a service dog is the tasks. I'm just going to shorthand this. The tasks performed for the person with the disability. So the reason I say we were humming along is because there are some great organizations that I've become more and more familiar with over time who do this. I mean, this is what they do. They train dogs, and they are very specific about where the dogs go, to whom the dogs will go. They train the parents. So a perfect service dog mediation, in my mind, and probably in Maura's too, would be a situation where everybody comes in together and we just, we know that this is a service dog because it's clear. Here's the disability, here are the tasks performed. It could be, and it doesn't, a lot of people think it's like, about somebody who has a physical disability. It's not. The task could be, like Jane said, someone starts to agitate and the dog applies pressure. It could be seizure detection. It could be just person starts to agitate and, there's a nuzzle or something. All you need is a dog that's trained to perform one of those tasks. Okay, then you're good to go. Then we're going to start to talk about the details. And before I mention the details, I'll mention that there are pressures that administrators face because there's a law that says we have to let the dog come to school if we've satisfied the definitional questions. And there's a lot of administrators who special ed directors answer to who aren't familiar with that law or think that it simply must not apply to a school district because, and many of you have probably heard these things, like other kids have allergies, the dog could be disruptive, all sorts of things that could happen. And truly bad things could happen, that's a possibility. But the law is pretty clear that once we're here, we just have to figure out how to get the dog into school, and that's really a great help for mediation. And our system is awesome because when I talk to people about the nature of a dispute and having to have a dispute to come to mediation, I say, well, we're pretty good about how we define a dispute because the Wisconsin special ed mediation system is allowing us to use services here through the program to be able to hammer out some of these details. And the pressures that special ed directors face from the people they have to answer to are real pressures. So it's really important for us to answer these questions so that director is able to go into a supervisor and say, yep, service dog, no choice, let me do my work. I think the problem that we had not anticipated earlier was what happens if these questions can't be satisfied, because for a long time they were always satisfied. These organizations would come in. Pause for Ability is one that we've worked with and a lot of families have worked with. And they can give you like sheets of instructions. They know the child, they know the dog, there's a system. Everything is worked out. The dog might not even need a bathroom break throughout the day, for example. The dog is not going to be touched or interacted with at school because the dog is working. And so when we talk about the details of, when is the dog going to be with the child and what happens if the dog starts to get agitated? In one case, the family says, well, we'll have a crate available so that the dog can be taken to the crate if agitated, and then we'll communicate about whether that's a problem. Very open discussion. Family says, I don't know that the dog should really go on field trips. That's a little bit higher level for the dog right now, so let's ease into that and make that case-by-case determination. Lots of reasonable and productive discussion. But we've got all those pieces in place. What if we don't have the pieces in place? So most people coming to us know the answers to these questions, and recently we had a situation where that was not clear. And so when we ask tasks performed, and the response that we're hearing back is emotional comfort and support, we're thinking, well, that puts everything into a different pot. Because we've got the service dog here, but then we have the emotional support dog here. Is an emotional support dog important? Absolutely, there's no question, but the law is different. So while we have to accept the service dog as a school district does not have to accept an emotional support dog. I have many clients who have done it anyway. They've said, I don't care if it's here or if it's here, this helps the child. I see that, this is a good thing, we're gonna do it. We go to mediation and we can figure that out. Other special ed directors may not be in a position where they can go to their superintendent and say, I want to take this emotional support dog. It has to be under the required category. So what can you do? One thing that we have done is we've asked more questions. And in fact, in asking more questions, we finally have some responses that help us to put it here. But it takes a lot. What tasks? There are no tasks. It's an emotionally comforting thing. But if we talk with the family enough over time, we might be able to put it here, and we might not ever be able to put it here. But this is the first one. Yeah, Sue.
I just spent 2 days at the sports show showing dogs, training people about dogs. No matter what you do, you're training your dog.
Mm-hmm.
If you let your dog on your bed, that's because you trained it that it's okay. My dog is never on a bed or any piece of furniture. I say it's not okay. I don't care where you put it, but you trained it. So everything you're doing is training your dog. If you taught the dog to jump up on your lap when you do this, you've trained the dog. It's a specific task. I don't know how any dog that you own that is the worst dog in the world wouldn't fit task perform.
Right. You just have to be able to articulate it. You just have to be able to say it, and that's why advocacy from someone who can help you say it can be very, very critical. And I think the other issue that everyone faces is that some people get very excited about having this dog, but the dog may not be trained the way that you're talking.
Because they allow the dog to do things like lick other kids' faces. That is not okay because
Right.
they're not actually training. They may train the dog to jump up, but they don't know how to train the dog to not do certain behaviors.
Right. And so one thing I've suggested when a school is concerned, like it's not here, it's not the pause for ability people who are going to give you the 4 pages and the dog is all in good spot. What if you're worried about the dog not being trained? Because under the law, once you get here, you cannot require specific training. You can't ask for specific training. You can't. In mediation, we'll talk about those things because it's mediation. But at the end of the day, you can't require it. And so one thing I've suggested to districts is if a dog's coming into you and you're worried about it and you got to let that dog in because they fit the definition, there's nothing preventing the school district from contacting somebody who has dog training abilities and saying, this isn't our dog, but the dog's going to be present at school. Could you partner with us? Could you partner with the family? Could you give them some support? There's nothing preventing that from being a potential outcome when you're not sure where it fits or it fits here and you have concerns about the training.
Can they no longer allow the dog to come in because it has not handled specific things? So like a really low-level CDI or good citizenship thing, like any dog should be able to do. But part of that is I should be able to give you the leash and go to the bathroom.
Right.
And not come back because I got into a conversation. And if the dog is not able to do that, can they decide the dog can't stay?
If they see the dog do something disruptive because the dog can't do that, but the problem is they can't say, is the dog trained to do X, Y, and Z? And if the answer is no, they can't say, I'm sorry, the dog needs to be trained to do that. Not allowed. They would have to let the dog in, and then if the dog is disruptive, then they could say, I'm sorry, that's not working out. And so that's part of what we're trying to have a conversation about in these situations, is so that families understand if you prematurely bring the dog and the dog's not trained, it could be a concern for your liability. It could be a concern for the dog's success in school. If we do this together and we get resources for you and for your dog, this is all going to turn out better for everybody, is the hope. And that's why I think mediation is such a spectacular vehicle for those discussions, because they're confidential, because even though you can only ask these 2 questions outside of mediation, inside of mediation, talk about whatever you want. You can figure it all out. You can talk about your concerns, about what your supervisor is going to say, about the kid with the allergies. You can have the whole conversation in mediation. Okay. Yeah.
Have you ever had to deal with other parents, and then if you have, how do you deal with the confidentiality issue?
Yep, it's kind of the same way we deal with other parents when there's a child who is having difficulty with emotional regulation, and that may have impacted their child, and they say, you know, I want this other kid out, or whatever, you know, if they don't like that the dog's there, there's allergies. I have not yet been in a situation where anyone has sued us or there's been any legal action. Every single district I've worked with has been able to sit down with the families individually and just said, look, we have a responsibility to allow the dog in school, and that's all they've said. But let's talk about what we can do for your child to, you know, make sure that your child is healthy, or if they have asthma or a concern about an allergy, you know, separating them. It's always worked out to date. Because people are alarmed, you know, and there's a lot of those what ifs coming up, and sometimes they're not what ifs, they're actual situations. But I've seen some great people really just sit down separately and talk about what are your child's concerns. I can't talk about that other child, but the dog's going to be here, so here are the choices.
One of the topics that, and I've had a couple of dog cases now, but one of the topics that is very helpful to discuss is how it's going to be obvious there's a dog in the school. And how are you going to roll that out? How are you going to make the school community aware? Oh, there's a dog here, and why is that dog
Right.
here? So that you don't get a situation where everybody gets to bring their pet to school. No, that's not what we're talking about. And so districts have been very good about working with the family as to, in an appropriate way, without disclosing more medical information than they would need to, but to talk about why that dog is there and what it means and how it affects other families or allergies or
Yeah.
things like that.
And one thing that I'm going to just, if you don't mind me mentioning you, is that I think was really helpful is that Maura was able to draw out these questions without making a suggestion that there was any kind of conflict or controversy. It's just an issue to be discussed. And I think that is really important in so many mediations where we're coming into the mediation not because we have something that would really rise to a full level dispute, but it's a discussion outside of the IEP team, or, you know, just to have that confidentiality, because this is a great place to have those kinds of discussions. Doesn't mean that we are going to disagree about this. And when the questions are posed by the mediator in a way that doesn't suggest that there would be disagreement or that this is a hot button issue, just oh yeah, what are we going to do about, you know, what are your thoughts about this? It's a very helpful style, I think, not just in dog cases, but in other cases where people are coming to you because they need a different process than the IEP team process, but there's no real huge dispute.
And it's very cool if they bring the dog to the mediation. Because then you actually get a much better sense of what that dog can do and how the dog behaves, and they're amazing dogs, the ones that are specifically.
The ones that are very clear here. But if they're not, we learn something too.
Right.
I mean, I just learned a lot in a recent mediation that, you know, not all dogs are gonna, my expectations are that they're all gonna be like perfectly trained, but if they're not, it's like, okay, well now we know what we've got going on here and we need to figure out what to do. Better to know that in the mediation than day one of dog arriving at school.
Two more issues to discuss. They dovetail one another, behavior, but then also mental health issues. And again, as I said, this arose from our discussion about what are the trends we're seeing, the concerns we're seeing, and truthfully, the two issues do relate. So I am going to talk for a few minutes about the mental health issues that I have seen an increase over time. I am seeing mental health impacting a child's ability to access their education, and I'm seeing kids at a younger age being impacted by mental health, and I am seeing a wider array of issues. I have many students that I work with with anxiety. And usually anxiety, from my experience, it's paired with another issue going on. And oftentimes it can be a student with ASD, someone on the autism spectrum. And that anxiety has a real impact that can't and shouldn't be ignored. So that's one issue, is the anxiety, but then the other are the pretty significant mental health issues. And for some of my clients, that means having to go to an outside placement, a private placement, or maybe a half-day program at Rogers. And so all of this leads to what's the impact at school? As I said, accessing their education, but then also school supporting the surrounding issues. I am pleased to see over time districts understanding more and willing and acknowledging the need, actually. So I wanted to talk about a framework that DPI has put out back in December 2015. They rolled out a Wisconsin School Mental Health Framework, which I hope districts are reading. I'm hoping a number of people in districts have this document and have it tabbed and flagged, because I think it's a good basis to work from. And I included the site on my, it's at, Renee and I flipped ours, so this is at the last page of our outline. I apologize for not saying that earlier. So and Renee, are you, your clients are aware of this?
I hope my clients are aware of
Good.
this. I think so.
I'm glad to hear that. So the concept is a recognition that, first of all, it impacts a student's ability to stay in school and to get an education. And in my mind, if the various administration and staff stop and think about how it can impact their ability to educate in the classroom and the ability of other students to get an education, it just makes sense to address the issue. And the issue is at different levels. And so they talk about a multi-tier approach, which makes a lot of sense to me. What else I liked about the framework is they talked about some universal supports, meaning let's work on these issues for all students, regardless of whether they have an IEP, whether they have needs now, just to make healthy students with good emotional health. So I appreciated those ideas. You saw my quote here where they talk about a recognition of addressing barriers to learning, including mental health challenges, through learning supports is an essential function of school. I personally saw that as a kind of a philosophical shift. In the past, I was told, well, that's great. We understand your client has some issues. Go get that taken care of, and we stand here ready, willing, and able when you come back. And that was difficult because this child needed and deserved an education, but they were having problems. So I see this as a philosophical shift that we're going to work together. And the together, they talk about a collaboration of school, family, and community services, the mental health providers in the community. And then the other goal that they talk about in the framework is this goal of kids graduating being socially and emotionally competent. Simple and yet critical. I think a difficulty for schools is they have so many hats, so many roles. You know, we're always talking about accountability for the academics. Well, this is, you know, something that is pretty different from all those academic subjects and all the requirements schools have to be providing and assessing and progressing on. But I would maintain without this understanding, recognition, and implementation, you can't get to those academic progress. So it's just a reality of where we are. So the types of issues, they talk about, as I mentioned, this continuum of services, the universal services for all students. Then there is a recognition of some kids will need an extra level of support and what that might look like. And then that third tier they talk about are kids who, as I mentioned, may actually need some pretty significant mental health assistance, and some schools are actually collaborating and having some of those mental health providers in school. Not that they are funding those providers, but rather making space available to those providers to meet with their clients during a portion of the school day, which allows the kids to remain in the school building, in the school environment, and go right back into class when they're done there. To me, that's pretty innovative. And I was pleased to see that, and I have worked with a district that had that type of model. And unfortunately, I just think that may be more of the wave of the future. Unfortunately, that we're there, but I like the innovation, and I think it has a lot of benefit for all. So they talk about, you know, what are best practices. Let me just list some of those. They talk about training for staff. I think that's critical. The kind of training they talk about is, you know, understanding what are the elements, what should we be looking for a student, what does mental health issues, how might that manifest itself, and then what should we do about it? What are programs in the community we might refer families to? How can I be supportive for that student? They talk a lot about relationship building for students. It's what Renee and I talk about a lot, that trust, that, you know, that family trust with school, same idea. Teacher support for students. They talk about what to do in a crisis for the part of this staff training. There's also the discussion, as I mentioned, about working with the family, acknowledging the family has a lot of information and knows their child best. That's not an easy concept for some, you know, from what I have observed for some districts or for some people in districts, but it goes a long way to helping with that trust factor. And that trust factor is critical because on the flip side of it is districts asking for information like a medical release so that they can collaborate with the providers. That too is not an easy issue. We're talking about trust in giving some pretty sensitive information. So, Renee earlier talked about records requests, families making requests to districts. Now this is district staff making a request to a family to get a medical release. Starts with, and the only way it's going to happen is with that trust between family and family and school. I've actually had a number of issues on this topic, and to me, an important element of this is who really needs to know this information? How can we make it a narrower release? These releases are generally pretty broad, and it's like, just sign and we're good to go. But I would suggest that a more tailored release is more likely to get get parents' buy-in and more appropriate. So we talk about the who needs it and what do you need, and how is it going to be used by the district. Yes, Jane?
Should we see a lot in mediation, that the district has asked the family for some kind of medical records and they're refusing to do with them?
Yes, I would agree that that's an issue. Yep, an issue for families, and in my experience, it's because of some issue that has previously occurred for families. I was thinking about that. I have a few examples. Either the district may have misplaced the document, that like they've given releases in the past, and the district doesn't know where those are, or say they don't have the documents, and that, that's a concern for the family. Another issue I've heard from families is that they have heard that staff are talking about their child in the hallway, in the teacher lounge. Maybe the older sibling comes home from school and says, oh, I heard them talking about my little brother this morning, and it's in the hallway. Those are the situations that don't provide families with willingness to just sign off. So I just caution that that's a reality. The flip side of it is, in order to get that collaboration, I can see how they'd want to involve the medical provider. What I often do is have the medical provider participate like in an IEP meeting over the phone for a limited amount of time. So because it's an efficient way to do it, it's very hard to get that match up, for the school, even if they do get the release, to connect up with the medical provider. These are all busy people who are, going from client to client, and that makes it hard. Yes?
Can you give an example of how you might tailor a release as opposed to just saying a release from such and such entity?
Yes. So, as I said, most of the time it's just like check the boxes that we want the district wants all documents, and they want the ability to talk to the provider. So I ask, well, who's going to be calling? Is it the special ed director? Is it the school nurse? The school psychologist? So who needs this information? And who are they going to share it with? And if they're getting documents, specifically, is there a particular report? Maybe there's a neuropsych report and there are some specific questions on it. One way for me to address this is to have everything go in writing. So district has some specific questions, can you put it in writing? And then the answers will come back in writing, and we all get the same information. Downside, it takes time. I mean, that, usually we're in a crisis situation. We're here because there's a problem. So the other way I've done it is, let's do a 3-way call. Let's have the parent, the particular person from the district and the medical provider on the phone. Why is that a good idea for me? Because then they're all hearing the same information. What has happened for me in the past on occasion is staff from school will report at an IEP meeting, oh, I talked to the doctor and this is what they said. And the parent is stunned. It's like, oh, come on, they wouldn't have said that. So that's not efficient. There's been some kind of miscommunication, or we're not hearing the whole story, and then we have to start over. So my preference is to take the little extra time and consider who's the most likely person, who would be the most efficient person to get this information, what are they going to do with it? And then I take it one step further, and what are we going to do with it after? You know, Renee talked about the psychologist reports going in an envelope. Well, I would do that, but then sometimes we make arrangements that if it's a particularly sensitive report, I ask that when we're done with this, that the documents all be returned to us. And we have done that on occasion. I would say it's not like I'm always doing that, but on some occasions for some of this information, that's a way to get the buy-in, to get a resolution from the parties.
Thank you.
Any other questions? Let me just check. Okay, I better wrap it up. So, at any rate, I would encourage people to look at this school mental health framework. They give some examples in there of how districts have coordinated with various agencies, community agencies, such as the Boys and Girls Club, such as community trainings on suicide prevention, such as when I talked about those universal programs where they are doing skill building throughout the day rather than the fourth grade class goes to the guidance counselor for 20 minutes, once a week. They're trying to embed it throughout the day, making it more natural and making it a part for all students. I think that can only benefit all parties. Okay. Renee,
So I'm going to talk a little bit about behavioral discipline. One thing I wanted to mention about what Patty just talked about is the fact that a lot of times with mental health issues, the difficulty that the district faces is funding. And so there's concerns about the funding, which people shouldn't be talking about to family normally because that's not supposed to matter. It shouldn't matter, but then it does. So in mediation, sometimes we've discovered that a district wants to help out with something but doesn't have the funds or believes that that's the responsibility of the county. And the parent just wants the service for the child. And so in a lot of situations, we've been able to partner. And instead of looking at the situation saying, well, it's the parent versus the district, it's really the parent and the district wanting some funding from another source or wanting for another entity to provide a service. And so we've been able to come together and then approach that service together as partners instead of, against each other. And that's been really helpful. And in fact, a long time ago, we had a situation where a child had not only mental health issues, but was also deaf and was not able to really benefit from what was available here in Wisconsin. And the partnership involved county, school district, parent, DPI, all together. To come up with a workable solution with everybody kind of doing their part, and everybody contributed to this solution, and it ended up being a private placement that was expensive but necessary. And if it were just the school and the parent, trying to work it out, that would have been tough. They needed to come together and bring other people in. So, all right, so the last part of what we wanted to discuss has to do with relatively new guidance from relatively new guidance from the Department of Education, which is still up on the website. So it's there, and it exists, and it is on page 4. And it talks about a few things that I want to highlight, because I think a lot of times when we get this new guidance, at least, I don't know, I think Patty and I feel like you look at the guidance and it's not earth-shattering. It's not like there's all this new information that we didn't ever know before, and I'm sure DPI feels the same way. It's like, thanks. This is what we've been doing for a while. Thank you, federal government. Hopefully that means that's because we're doing a lot of good things in Wisconsin and people are doing things correctly. But this Dear Colleague letter that I quote from pretty extensively, I find it interesting to look through and see, are there kernels of information, anything new, or anything emphasized that we might be able to use? And I say that because one of the jobs of a lot of special ed directors that I work with is to be able to justify decisions that they make, to be able to train their staff to do what they're supposed to be doing, and any little bit of extra that comes from the Department of Education is helpful to them in doing that. It's not just one person sitting in their office saying, do this. There's authority behind it. And so as we look through this, there's lots of little pieces that we've been using in school districts, and that actually I have used as a parent in terms of talking to people about what needs to be done and how things are changing, how things are shifting. And so you can see right here at the top, when it there's a quote from the beginning of the letter talking about the fact that there is a problem, that kids aren't receiving behavioral interventions that they should be receiving. And then it goes on to talk about what's FAPE, and Patty talked about that before, so I won't repeat it. But it specifically addresses the fact that it's not just academics, it's behavioral. Now, we knew that before, we've always known that, but it's always good to have some emphasis. The parts of it that I see being a little bit different, or that we've picked out to talk with school staff about, number 2, safety standards. And it says that this letter is not intended to limit the appropriate use of disciplinary removals that are, and that is my emphasis, necessary to protect children. So when it comes to discipline, necessary to protect children is important. And I talk later on about suspensions and a section in there about suspensions and can we suspend versus should we suspend? And one of the main messages that I see coming out of this guidance is there are no free days. You've heard a lot of talk probably over time about the 10 days that children can be suspended for any reason, regardless of whether it's a manifestation of disability or not. And they've been referred to as free days, and the Department of Education says no. These are not free days. There are no free days, and in fact, when it comes to discipline, that's discipline that's necessary to protect children, not just because you can, not just because you have these 10 days. And so I think that's a really important theme of the guidance in general. And so a lot of directors have been able to approach their superiors and refer to this to say, you know what, you could technically suspend Johnny today, but should you, and is that necessary for his protection and the protection of others? What is the purpose of that? And then the guidance goes on in other sections to talk about the data and the research regarding suspension and what it's for and whether it's helpful or not. And the answer, as you'll see, I think I put it back here on page, maybe I put it on 6 or 7. And the answer is no, that there's not data that suggests that it prevents the behavior from recurring. And in fact, if somebody is dysregulated and engages in a behavior to escape, if the function of the behavior is escape, and the result is a suspension, then they have indeed escaped school by engaging in that behavior. So, you know, if it's necessary to protect that child, then that's one thing. But if the intent is, well, we're going to teach them a lesson or we're going to show them what happens if they engage in this behavior, a more thoughtful process is really necessary because the data is not demonstrating that suspensions have that impact. So important, I think, for people to know. So I've got all of that in here, but I'm going to back up to an earlier page so that you can have some tools. Tools that I think are intended to make everybody think beyond the behavior plan. Because a lot of times when we have a behavioral issue and we come into mediation to discuss it, the first thing that comes out is that behavior plan. And my concern is that sometimes it's the last thing that comes out because we're focused again and again and again on the contents of that behavior plan and not on the other supportive services. Now, I'm not saying behavior plans don't include supportive services because they often do. But what the Department of Education is saying is that there's a lot of other places in that IEP where we should be looking at what else can we be doing. And it's interesting to see the types of things that they list. I think that's because, let's see, I've got on page 5, examples of specially designed instruction. And that's where we have a lot of examples that I see a lot of people skipping by or missing, or they don't consider it to be specially designed instruction. So, instruction and reinforcement of school expectations. You can specially design instruction in that topic for someone. It's not reading, it's not writing, it's not math, but it is specially designed instruction. So if somebody says, well, we don't do that, that's for the psychologist or for the therapist, the Department of Education feels differently about that. The Department of Education believes that that is specially designed instruction that is properly placed in an IEP for a child who needs it. Same thing with violence prevention, anger management, and this one is huge. I probably should have bolded this because it's exactly what Patty is talking about. This is a tiny part of this big guidance, and it says right there in specially designed instruction as an example, counseling for mental health issues. I think that's a big deal. Because I would say that a few years ago, people would be pretty scared to say that that's specially designed instruction, and I think even now there's going to be a discomfort with that concept, but it's there. So we're trying to get our school psychologists, for example, more involved, not just in managing, being a case manager or running the IEP team meeting, but actually, providing psychological services. It's a related service in the IEP, and it can also be specially designed instruction. And so I think looking beyond those typical barriers is important. Life skills training and social skills training. Social skills training is a significant piece of a child's educational program for many children, and it is specially designed instruction. So it's not just, you did this wrong, here's how you should handle it. It's proactive instruction. Okay.
Sometimes districts say that they can't do these kinds of things unless there's ED label.
Right, no, that would be wrong. Yeah, no, it doesn't matter it doesn't matter what category the child is in, how they were identified as a child with a disability, whether it's EBD, autism, OHI, even if it's a learning disability, although I would wonder if a child's having significant behavioral or self-regulation issues, I'd suggest that the district explore other categories as well to see if they might qualify. Right. All right, so I list those. I also list supplementary aids and services. Same thing, examples here. These are great examples. Meetings with a behavioral coach, more social skills instruction, counselor assistance, and then 5, which is really big, in fact, huge, because it talks about supports for school personnel. And I think sometimes some of you have been able to detect this. The struggling teacher, the struggling support staff member, the person who's in your mediation and looks super scared because they're supposed to be doing something, but they don't really know how or what. And this section is just, I think, so important to highlight for everybody because, they could be sort of floundering and wondering what to do. And so this section of the IEP, so if in a facilitated IEP team meeting it's relevant, and it's also relevant in mediation, what kinds of supports, what kind of training do we need to get to staff? And I've found in my own personal experience that one might be very frustrated with how staff are doing a particular job, but rather than just assuming that they're incapable, turning that around to, well, wait, how are they feeling about this? Do they feel scared? Do they need more training? Do they need help? Where can they get that help? And then partnering with them to get them the help that they need as a parent, rather than saying, you just can't do this job. Maybe that's a possibility, and here's where that comes in. And so they mentioned that as well.
Yeah, it's a touchy subject, an important one, but you don't want the staff to get defensive. You know, so sometimes what I do is I raise the issue in advance of mediation, because you want to be cognizant of keeping this collaborative, and truthfully, it's not easy to say in a big meeting that person, you know, doesn't know what they're doing. Basically. So I talk about how this is a complicated case. What we've done, it's not fair to the staff. I tried to make it a little more general. Talk about it's not fair for them for us to put them in that position. You know, I try to soften that, but the easiest is if I can talk in advance, like, what can we do to help this person? Again, the idea is this is what's helpful for my client, and so I try to find a softer way to raise it.
Just in terms of resources that are available, Wisconsin Facets partners with DPI and a couple of other agencies, WISPY, to put on the Endless Possibilities Conference each year, and it's this year it's $30. So, you know, anybody, and it's, you know, we have a whole slew of, we rolled out, we're going to continue to roll out the mental health framework that you talked about. There's a bunch of, you know, a lot of strategies for, you know, addressing these issues that you just talked about, program modifications and supplementary aids and services. This year we're going to have one of the mothers who's a mental health professional, PhD, who's the mother of one of the Sandy Hook survivors, or children that didn't survive, I should say, that was killed at Sandy Hook. So, you know, which was a whole mental health issue. But, you know, so if you happen to be in a mediation where, you know, you want to suggest or, you know, talk about what resources are out there, you know, we have it. It's the first week of August again.
Okay, yeah.
Thank you.
I see a lot of effort throughout Wisconsin to engage in the mental health issue. It becomes a real primary concern to many educators. For example, CISA 6 and 7 had created 6 years ago the Autism Academy, that we provided training to build capacity within building to deal with autism-related issues. The staff is now switching gears to mental health. We conducted a survey the last 2 months, seeking district feedback about what they have, what they need, and we're going to do the same thing with autism, but in the area of mental health.
Oh, that's great. That's good to know.
So if you have your magic ball, or magic globes, whatever, and you're looking in there and you're going, okay, we got the Department of Education, and we have the needs of mental health issues that are huge, and we have money that is or isn't there or isn't going to be there. How is this, you know, how is this going to play out? I mean, I want you to tell me.
Yeah. Do you want to speak to that first, or do you want?
No, I'll let you field that one.
Here's what I think, and I think this both as a parent and as an attorney representing districts. I think that that's where the relationship part is really important, because there are pressures of this world and things that will never be ideal, and we're never going to make it perfect. I watch clients make lots of mistakes. I watch my child's team make lots of mistakes, but what's ultimately most important to me and what I see as really important, it's not that people can just mess up all the time and not do good things for kids, but I think that sense of working together to try to solve those problems And in mediation, you can talk about so many things that you could never talk about in an IEP team meeting or outside of mediation. I think just the process of getting out what are the challenges and how do I feel about them it's really powerful. I mean, I think it really means a lot. And so I'm not saying it's going to solve every problem, because it's certainly not, but it gets people into a different place. And sometimes, like I said, identifies those situations where, well, wait, we need so-and-so to be helping us out with this funding, or here are these resources, or wait, there's somebody who can help, and then they contact CISA, or they contact Facets, or they're just brainstorming and the problem might not be solved. And that's the reason that the agreement rate, like maybe what agreement do you have? You don't have an agreement, but you figured out like a path or where to go next or what to do. So that all sounds really fluffy. I get that. But I think that that's why you guys are so important.
So micro-community is what you're looking at.
Yeah.
It's just gotta get small.
Yeah. Like actual just person to person. I mean, I can think about my own struggles with my own school and like just getting that communication back together, saying, what are your struggles? What are your struggles? I mean, it's huge. And I see that all the time in districts. And when people are humanizing each other and establishing personal connections, or like having lunch and, we're all sitting having lunch together and you're talking about something that's not the topic. And then people kind of like each other. And then that helps. It's a lot of that.
Yeah, I would agree. The idea of establishing the relationship. I would say for my clients, again, they come to me when
it's bad.
I only get when they feel this truly is the last option. But it's amazing to me that in most cases, if the district makes some efforts, if they can, even a little bit to work together, that starts them on the path together and rebuilding that relationship. And there are resources out there. It's a matter of finding them and being willing to utilize them, and oftentimes it's outside the box thinking.
That's true. All right.
It
Anything
is
else?
about, do we need to wrap this up?
Yeah, I thought we would, yeah.
Yep.
Are there any other questions? But we'll be around. You'll be around too.
Yep,
Right. So we're here.
Sticking around, so, thank you.